that one should accept as perhaps the way forward, or is there some scope of dialogue here in terms of whether or not lawyers, chartered accountants should be brought under the PMLA?
Well, first, insofar as chartered accountants are concerned, the notifications are already out. And there are two sets of notification. The first notification speaks about what are the designated business or profession which should be covered. And as Rohan mentioned earlier, the profession of accountancy, CSC, ICWA have been brought within the ambit. And then second is which are the nature of transactions which are required to be reported. Rohan mentioned about how the global network itself really protects the client privilege. But it's also important to note that the notifications which have come out bring out really two separate aspects. One is chartered accountants in practice. What are the things that they are supposed to do? So for example, if a chartered accountant in practice is transacting on immovable property or is operating the client's account or selling or buying securities on behalf of a client, it is obvious that he is doing something which a client ought to do. And therefore, such activities are bound to come within the reporting requirements. You cannot claim that you are acting on behalf of the client, and then if there is something suspicious, you still do not report about it, because your reporting requirements have to be contemporaneous or coterminous with the reporting requirements of the person on whose behalf you are reporting. Second is a notification which came out on 9th of May, which is a little bit ambiguous, which speaks about business and which speaks about the business of formation of companies, maintenance, etc. So to answer your question, when it goes to the lawyers, it will be interesting to see what is it that comes out in the notification, how are lawyers required to report, what are they required to be reporting on, and what are the exclusions from that requirement. If the exclusions are consistent with what are the global recommendations, then it will be there is nothing really to worry about, because then all that you're doing is to say that if you are doing acts on behalf of a client, then you are bound to do the KYC for the client. And if you find something suspicious, you are bound to report on it. So I think a lot will depend on the exact wordings of the notification, what are the transactions covered, and what is the reporting requirement.
Interesting. Let me take that across to Mr. Shah. Mr. Shah, I'll ask for your indulgence on this particular point that Mr. Kanabar raised with respect to what the wording may actually look like. What would be the areas of concerns from a lawyer's standpoint if it were to be included? You mentioned reporting as one concern, reporting of suspicious transaction as being one concern. What are these concerns that, if put on paper, could raise an issue here for the larger legal community?
I think just as Mr. Kanabar said, when you look at the reporting requirement, there are 5 categories of issues in relation to which you report. Now, it includes real estate transactions, it includes the formation of companies, it includes, in certain parts of the language, even day-to-day activities in terms of structure, organization, the investments into companies. So the width of that sort of seems A, nebulous, and B, it seems extremely wide. Because, if you think, let's say, essentially of a lawyer whose practice is in the real estate, it would then seem that, almost everything that they do needs to be subject matter of the maintenance of records. Likewise, somebody who is sort of entrenched in company formation, somebody who is entrenched in offering advice in terms of the conduct of the affairs of a company, again, it would sort of seem that, record keeping from their perspective would be quite wide. So I think it's important to sort of understand, what the true ambit of this is going to be. And if you see, I think there's a good guidance available in terms of the EU directive. Because what the EU directive sort of focuses on is to say that everything can, in a manner, be protected by privilege, other than if you are directly participating in an activity which would be a money laundering activity, or if as a lawyer you're directly participating in a transaction which is a terror funding transaction. So that, in any case, I think A, is morally not condonable, and even under Section 126 of our Evidence Act, the entire concept of privilege has 2 exceptions, and those exceptions include a situation where a lawyer directly is in the know and a lawyer directly is dealing with something which is then liable to be regarded as criminal. So I think if we sort of focus on the factor that some things are just not permissible, and I don't think there is any yardstick of being able to condone those. So if somebody were actively advising on a transaction of money laundering or terror funding, I see no reason whatsoever why there should be any sort of privilege in the context of somebody who has that. But once we say that this is what to be focused, then I think we can be a little more realistic in terms of where else we want reporting, where else we want record keeping, and how we make that more practical, and how we sort of ensure that legitimate businesses and legitimate activities can clearly coexist with the obligation to aid in what is, I think, now both a national and international cause, namely ensuring that nobody is really participating in money laundering or terror funding.
Right. Right. Mr. Shah, Mr. Kanabar, let me come to you for the final word on this. Mr. Shah was referring to, of course, Section 126 of the Evidence Act. It very clearly says that in cases where there's a client pursuing a property, possession of a property through a forged deed, that communication may not be covered under privilege. The question I want to then ask you is that these professions, when you look at accountancy, when you look at legal professions based on trust, based on the edifice of trust, in such a scenario, when they're already regulated under separate statute by various individual dedicated regulators, will this perhaps add to more the compliance burden? Will this make things more complicated in situations, as the example as Mr. Shah gave, a lawyer pursuing the focus of pursuing real estate transactions could find difficulties and challenges?
I totally agree with you, Ashmit. And I was just reading an article, particularly as it concerns the audit profession, on how audit has become such an onerous thing. So first, you are required to be a watchdog. And again, there is this whole issue regarding watchdog versus bloodhound and all of that. But leaving that aside, you are required to really look at transactions. You are guilty of disciplinary proceedings in the Chartered Accountants Act. We now have NAFRA and everything to be governed by that. And now, in addition, we have this reporting requirements. I think, Ashmit, I could actually break up the entire discussion if one has to focus on two parts. Insofar as the requirement is that you are doing activities on behalf of a client, and what a client cannot do, you cannot do for and on behalf of the client. And therefore, as Rohan mentioned, whether it is money laundering, whether it is terror funding or whatever else, if a client can't do, you can't do, absolutely given, I don't think there can be any two arguments. The question is that the notification, as I read for the chartered accountants, and I presume that it is something similar which will come for lawyers, is in some instances pretty vague and pretty so widespread. So as Rohan was mentioning, for example, if you are involved in the process of company formation, if you have been the initial director of the company, etc., you are sort of almost regarded as the person who's carrying on that business for the client, which may actually be only a service and nothing else. And for you to be regulated on that basis, for the reporting requirements to come in a situation like that may not be appropriate. So it's not really what is the important thing is the law, but the way, as I said earlier also, the way the notifications are worded, and if that ambit is very, very broad, then we are going to see practical difficulties in implementation, etc., not otherwise.
Right. Right, Mr. Kanabar, thank you so much for sharing your time. Mr. Rohan Shah, thank you so much for sharing your time and perspective on this one issue that is under discussion as we speak. And hopefully we'll begin to get more clarity once the Bar Council firms up a view and presents it to the government. But that's all the time that we have for. It's a wrap on this edition of Business 360. Thanks so much for watching. Our Friday Special Editors Roundtable is up next. Stay tuned.